I think, if I
Yes.
may,
Yes.
last time the other forum was accommodating around 90. So I think you can just wrap around for their sake, for the sake of the 10 that have joined for the first time.
Okay.
Yes, we will appreciate that.
Okay. So what I said is that you can only own interest in land, and interest in land can either be a leasehold or a freehold. A leasehold is simply having exclusive possession of land, of our interest in land for a definite period and with a rent consideration. Then the other one is owning land absolutely, which is a freehold. And I said that conveyancing is one course that deals with how to deal with your interest in land, how to restrain, how to use it to acquire loans from a bank. So allow me to start from I was giving you a brief summary of the transfer process. And we say that transfer process is whereby you are selling a property, you are selling your interest in land. And in that regard, I say that if you own an interest in land and you are in a financial constraint, there are so many ways through which you can deal with that land. Number one, you can sell that land. And in so doing, I say that the first thing is that you will find a potential purchaser. So in a transfer transaction, there are two parties. The first party is a vendor, who is also known as the seller, and the other party is known as a purchaser, also known as a buyer. So the buyer will be looking for land to purchase, and also the vendor will be looking for someone to buy his or her land. And once they meet, of course, they can do, the vendor can do this in so many ways. The vendor can choose to just put a poster that he is selling his land, this plot is for sale. Alternatively, he can use an estate agent who also has to be registered under the Estate Agents Act. When we'll be looking at other professionals in conveyancing, that is one professional that we'll be looking at. So the other, then after you meet, the purchaser will identify a land that suits him or her, and they will agree on the terms of that sale. And after agreeing on the terms of the sale, that's when they will now approach their respective advocates. And when they approach their respective advocates, the first stage is that their respective advocates would want to understand the transaction that their clients are just about to get themselves into. And this procedure, their respective advocates, depending on which party you are acting for, you may be acting for the vendor, you may be acting for the purchaser, you'll want to ask, which is the subject property? What is the purchase price? Is it vacant possession? Who are the parties? Is it a company? Is it a minor? If it's a minor, you know very well that minors cannot execute documents on themselves without a trustee. So a trustee will come in to execute on their behalf. So they will also discuss the aspect of the fee the fee to be paid, and the financial implications. So that stage is very important, the initial client interview. Thereafter, the advocates will proceed to do what is known as due diligence. And I say that each party has a role to play when it comes to due diligence. The vendor's role in due diligence is simply to deduce the title. What is to deduce the title or deduction of a title? It's simply to prove that you own the interest that you are about to sell. You own it. And how do you do this? By providing an abstract title to the purchaser. An abstract title basically is a schedule of documents, including a copy of the title deed and the relevant consents which are required. Thereafter, the purchaser will now bear the burden of the due diligence. The other thing that I need not to forget is that the vendor is also expected in that stage of due diligence to disclose latent defects. There are two types of defects. There are latent defects and there are patent defects. Latent defects are those defects that even if you exercise which degree of due diligence, you cannot discover them. So they are not discoverable even after conducting your due diligence. So this may be on the history of this land, something that is so much hidden. So it is the duty of the vendor to disclose such defects. And then the purchaser will now take it up from that point to one, do due diligence. And due diligence, there are three mediums of conducting investigation of title. Number one is through requisition. Number two is pre-contract inquiry. And the famous one, doing searches. So there are three types of searches. There is personal search, also known as the hand search, which is done by the members of the public. And remember, at some point, this was suspended because documents were getting mutilated, some were disappearing. And so what happened is that it was closed, it was suspended, but the Law Society of Kenya, they raised a complaint, and now the hand search or personal search is only opened to advocates. The other search is the official search, also known as postal search, where you make an application and the search is conducted by an official at the registry and they give you a certificate of search thereafter. There is also historical search. There are also requisition, simply are forthright questions on the title you've received from the vendor. So if there is something that you don't understand, that brings in the aspect of requisition, where you now ask forthright questions. Thereafter, there is also pre-contract inquiries. You want to inquire on this land, the location, is it accessible? So all those things, they sum up to be investigation of title. There are other departments that you will also want to visit when you are investigating the title. So many departments. If the property is owned by a company, you will be required to go to the company's registry to know the directors. Why? Because it's the directors who will transact on behalf of that company. If it is through succession, you'll need to go to the probate registry. To ascertain the boundaries, you'll go to the survey department. To just know that, to just ascertain that there is no legal tussle in that land, you'll have to go to the court registry. And mostly this, you can even type those, the title, the say title in the Kenya law, so that if there is any case that revolves around that, you are able to note. You'll also go to the county departments to understand, are there any rates that have not been paid? What are the development hindrances? What are the notices? So that process, those processes, we said, they are known as the pre-contract stage. They take place before you can actually get into a contract, before a contract is drafted. So the pre-contract stage entails identifying your land, number one. Number two, it entails initial client interview. And one question that keeps coming is, what information would you require during an initial client interview? And I have tried to highlight them. The third thing is that there will be investigation of the title, which I have provided 3 mediums of investigation, and also other departments to visit in order to conduct investigation. The other thing is that you may be asked the rationale for investigation. Why do we need to do investigation? Number one, caveat emptor, buyer beware. Number two is that the bona fide purchaser for value. If you buy and you do not have any notice, then that title cannot be defeated. Then the other aspect is that just to protect yourself from any legal implications, so that you can be, if you don't conduct due diligence, you can be sued for negligence. So that stage is known as the pre-contract stage. Then we have the contract stage. The contract stage is a stage where now the contract is drawn. The contract in a transfer, in a sale transaction, is known as a land sale agreement. And land sale agreement, to understand it better, there is the LSK conditions of sale, which governs that sale. And there is the latest edition is the 2015 edition. So you need to understand something about enforceability of contracts in disposition of land. And what is the enforceability? The enforceability requires that is under Section 3 of the Law of Contract Act, as read together with Section 38. Number one, that contract has to be in writing. Number two, that contract has to be executed by both parties. And number three, it has to be attested to by a witness who was present when those parties executed. It is at this contract stage that deposit is paid. And you may be asked, what is deposit? It's a percentage of a purchase price paid during or before execution. And it's always paid by the purchaser because it's part of the purchase price. And you may also be asked, how is it held? It can be held as agents or as a stakeholder. The advocate of the vendor holds it as a stakeholder or as an agent. You also may be asked, what are the importance? Number one, it reduces your burden of having to pay the full purchase price at a go. Number two, it creates a symbiotic relationship which can be enforced in court. It also gives the purchaser the right of a lien in the documents of the vendor in case a vendor refuses to proceed with the transaction. So a land sale agreement will be prepared at that time. And one thing you also need to understand that a land sale agreement is always prepared by the owner of the interest in land. And the owner here is the vendor. Then you move to the next stage. The next stage is now the completion. Why do we call it completion? We call it completion because it is at this stage that now parties fulfill their obligations under the land sale agreement, so that the purchaser will be bringing the balance of the purchase price, and the vendor will be bringing the documents to enhance or to enable the property to be transferred from him to the purchaser. And these documents are what are commonly known as completion documents. They are just meant to complete the transaction. You need to understand what are these completion documents, which we shall be discussing in our subsequent classes. Right now, I'm just doing an highlight of the process. And again, there is some aspect of time being of essence. If it was provided that time is of essence, meaning that the timelines in the contract have to be adhered to. If you fail to adhere with such timelines, then the party which is not in breach can give you a notice, and this notice is commonly known as completion notice. So you will also need to understand how to draft a completion notice. What are the prerequisites of a completion notice? So it is at this stage, the completion stage, that now an instrument, the actual instrument, which is used to transfer or to convey the land from the vendor to the purchaser is prepared. And this instrument is not land sale agreement. This instrument is known as a transfer. I repeat, land sale agreement is only a contract. It does not transfer land. The instrument which now transfer land is an interest in land is the transfer. And the transfer is now prepared by the recipient of the interest. It's prepared by the purchaser. So the purchaser will prepare the transfer and submit it for approval by the vendor. And this shall also be executed. And it is this transfer now that will be registered to transfer the land from the vendor to the purchaser. So this transfer is always executed even before completion. Some people even love executing it during completion. And you may also be asked, what is completion? And what is the completion date? What is the completion venue? But one about completion date, parties are free to agree on whichever date they want to complete this transaction. If you have money, you can even agree on 30 days. You can even agree on 20 days. You can even extend it to 120 days. But the LSK conditions of sale provides that in absence of such agreements in the contract, the completion date is 90 days after the execution of the contract. So that one you also need to understand. The completion venue as well, you are free to agree in the land sale agreement on whichever place you want it to be conducted. But failure, the LSK conditions of sale provides that it should be in the offices of the advocate of the vendor. So remember, I have introduced another document, and this document now is known as a transfer, and it is this transfer now that conveys land. So this transfer, the Stamp Duty Act provides that you, for every instrument in land, unless exempted, you have to pay stamp duty. So after completion, the next stage is the registration stage. But before the registration stage, you have to pay stamp duty. Stamp duty, the consequences of stamp duty, you have to understand which instrument are you dealing with. Is stamp duty paid? Is stamp duty payable? And what is the percentage? What are the rates? So different instruments have different rates. For example, a transfer, like what we are dealing with right now, a transfer will also, another question to ask yourself is, what is the purchase price? Because that purchase price will be used to calculate the stamp duty. And stamp duty will also depend on whether the property is in a municipality or a town or in the outside a municipality. If it is inside a municipality, it is 4% of the purchase price. And if it's outside a municipality, it is 2% of the purchase price. Then after payment of stamp duty, of course, you will have to understand the process of payment of stamp duty. What is the procedure, lodging the documents, the valuation, and etc. You will have to understand all those procedures. And after that, you now proceed to register. That now you now register the transfer. Of course, you have the completion document. So you will attach the completion documents to the transfer. It is the transfer that will be registered, not the land sale agreement. The land sale agreement is simply a contract. But with regards to the transfer or the conveyancing, you will have to use the transfer. So the transfer will be registered, and you also have to understand the procedure of registration of a transfer. And after that, the land now belongs to the purchaser. You have to conduct a post-registration search just to ascertain that everything is okay. Everything has been registered as you desire. And that is the land sale process. In between, we will be discussing things to do with power of attorney. We'll be discussing professional undertakings. So we'll also be discussing so many other nitty-gritties, capital gains tax. Who pays capital gains tax? Capital gains tax is paid by the vendor on the net profit that he has obtained after selling his property. So that is one way through which you can deal with your land if you are in a financial crisis. Number two, so in this case, you will be losing your land because you will be selling it. You will be transferring it. Alternatively, if you don't want to transfer your land, you can decide to lease it. And that is another topic in conveyancing known as leasing. That simply is giving an exclusive possession to someone for a definite period of time upon payment of rent. And at this rate, we will also understand what are the essential elements of a lease. What are the duties of the parties, the covenants on part of the leasee. So in this case, the parties now change. We no longer have the vendor and the purchaser. Here we have the lessor and the leasee. So the lessor is the owner of the land, and the leasee is the recipient of this interest, exclusive possession. And then this rate, this topic, we shall also be distinguishing a lease and a license. There is a distinction between a lease and a license. A license simply is permission to use land without being granted exclusive possession. That is the main distinction between a lease and a license. So you are using that land, but you do not have exclusive possession. You may be wondering, what is exclusive possession? Exclusive possession basically is that aspect of excluding everyone from that land at that period of tenancy, including the landlord or the lessor. Landlord is also, you can use them, landlord and the lessor can use them interchangeably. You can exclude them except when that landlord gives you notice either to inspect or to repair. So that we will also discuss the leases. And now you may also not want someone to come to your land. You know, if you lease, someone will be coming to your land. And so this person will be staying in your land or will be doing something in your land. So alternatively, you may not want these people to come to your land. So you say that I still want to use my land, only that I want to use this land to obtain loan to develop this land or to do any other thing. And that brings us to the topic of today, known as charges. Charges basically is using your interest in land to acquire loan from a money lending institution. There is something I failed to mention in leases. In leases, unlike in land sale agreement, when we come to leases, the process is known as lease, and the document, the contract, is also known as a lease. So you see, it's easier. The process is a leasing, and the contract is also a lease. So it is this lease which shall be registered. So if you understand the process, again, it flows. A lease is prepared. After a lease is prepared, it is to be executed. After execution, you pay stamp duty. After payment of stamp duty, it is registered. But then there are so many things I will say in between. What is the effects of non-registration? And what is the effects of non-payment of stamp duty? Those are some of the things that you need also to understand. When we come back to now, you want to retain the use of your land, only that you want to use this interest to borrow loan from a money lending institution. That is known as charge. So what is a charge? A charge basically is using your interest in land to secure a loan without transferring it. And that is the main distinction between a charge and a mortgage. Mortgage is not so much popular here in Kenya. But what happened in mortgage is that you will transfer your land to the bank, meaning that the bank will be the owner, so that after you've paid the loan, they will retransfer or reconvey the land back to you. But that is not happening in charges. In charges, you are simply using your land as security. When you use your land as security, it shall be known as an encumbrance, and it shall only be recorded at the encumbrance section. So what is a charge? Let's begin. What is a charge? So basically, it is using your property as security for loan without necessarily conveying this property to the bank. And the parties to a charge are, number one, the charger and the chargee. Mostly we will have two parties, but in certain circumstances, we may have three parties, and that is in third-party charges, which we shall also discuss in this. So the bank is also known as the chargee, and the bank can be known as the chargee. It can also be known as money lending institution, while the person who is borrowing, who is using his property to secure or to borrow loan from a bank, is known as a charger, also known as a borrower, also depending on whether it's a third-party charge or not, which we are also going to discuss. So what is the procedure of a charge? You will not just wake up and call charges and call for loans as if you are calling any person. You have to make a step. And what is the step? The step is to identify a bank of your choice. After identifying a bank, you go and make a formal application. A formal application that you need a loan from the bank and that you have a property. Could be a property in Vihiga, could be a property in Nairobi, could be a property in Sindo, whichever place. So you want to use this bank to borrow loan. So you go to this bank and you make your formal application. Now, what next? First thing the bank will do is to value the property, valuation of the property. Because you may want to borrow a loan of 100 million, yet that land is not even worth 10 million. So the first thing, which is an internal process, the bank will want to value the property. And this is an internal mechanism. They use professionals, valuers. This is not your work as an advocate. It's upon the bank to value the property. So after the bank has valued the property, they also do something known as credit assessment. now that Tonje is borrowing loan, is he creditworthy? Or is a perennial defaulter with the Tala, all those banks? Tala, you see, I'm just using Tala because of the recent development where everyone is being taken to CRB. So what is the creditworthiness? So these are internal processes. So after the bank has confirmed that indeed you want to borrow 100 million, let me say you want to borrow 50 million and your property is worth 100 million after valuation, they put a tick. They have already done a credit assessment and they know this guy is a good one, they put a tick. Then now they give you an offer letter. An offer letter. This offer letter, sometimes it's referred to by some scholars as happy letter. Others call it love letter because it brings a smile on your face because you're getting loan. So you will get that offer letter. That offer letter will basically provide or enumerate the agreement between you and the bank in terms of the agreement in interest rates, the period upon which you, the duration upon which you are supposed to service this loan, then all those aspects, the money that, the loan that you're going to borrow, etc., and the duties of, the document that you need to have. So after that is done, now the bank and the chargee, the chargee is the same as the bank. The chargee and the charger will now retreat to their respective advocates to give them advice on the same, on the process. So one, the banks usually have advocates on retainer. Most banks have retainer advocates, while maybe the charger will want to look for his advocate. So at that point, when, let me just skip, I know I'll come back to discuss a few things there. So let me just take you through the procedure, then I will come back to pick up from the beginning. So after getting the offer letter, it is after these instructions, then the bank now sends instructions to their advocate, just simply instructing them on securities perfection. Security perfection simply is just the process of registering a security, preparing all those documents, etc. So it's after this that the instructions are sent to the lender's advocate on land securities perfection on the borrower's title deed in respect to the loan application. So after this, the bank will have to write to their advocate and they will inform their advocate on the details of the parties, the amount to be lent, the repayment period. Is it 36, mostly it's in months? Is it 36 months? Is it 60 months? Is it 48 months? Is it 24 months? Then the details of the intended security. Is it a formal charge or is it an informal charge, which I am going to discuss in a short while. And of course, you also need to attach at that point of application and making formal application, the vendor, the charger is expected to provide certain documents. Some of these documents, the title document, the PIN of this borrower, the ID of the registered owner, that is if it's a third-party charge, which I'm also going to discuss, then a copy of the ID of the spouse, because you know the spousal consent when you're dealing with matrimonial property, then the application itself. So once these documents reach the advocate, now we are discussing the duties of the lender's advocate. Once these documents reach the vendor, the bank's advocate, the first thing is they will advise the bank on the appropriate security. Are we going for a formal charge? Are we going for an informal charge? What are the advantages of a formal charge? What are the disadvantages of an informal charge? Then we talked about requisition. Requisition simply, we said that there are forthright questions on the abstract title. What did we say an abstract title is? And what is the role of any owner of an interest in land with regards to investigation? We said that they have to deduce the title. And in induction, they provide an abstract title. So in providing an abstract title, if there are any queries, if there are any clarifications that you need, so the same process will also apply here. The charger being the owner of the interest in land, will have to deduce the title by providing an abstract title. So the second thing that the charge's advocate or the bank's advocate is expected to do is to send requisition if necessary. Then the other thing is to do a proper investigation. You know the investigations, we had talked about them when we were dealing with the process of land sale transaction. The investigation normally is just the same. You will need to do a search, maybe personal search, historical search, or an official search. You may need to do pre-contract, you may need to engage yourself in pre-contract inquiries, and also visiting relevant registries, just to ascertain that you are actually transacting using a clean title. After that, you can also advise the lender, on the need to do a physical inspection of the property. They need to do a physical inspection of the property. Then what next? What next? You also need to confirm the capacity. You need to confirm the capacity of the borrower. Is the borrower a company? If it's a company, who are the directors? You see, now you are conducting your due diligence, because as an advocate, you don't want to get into a transaction, then in the middle you are stuck. Like we say that cases are won in chambers. In conveyancing, transactions are actually best completed during investigation. If you investigate and you know very well what will be required, then you are good to go. So you confirm the capacity. Is he a minor? If he's a minor, who is the trustee? So after you've done with the investigation and confirming the capacity, now in this case, it is your responsibility. It's the responsibility of the advocate of the bank to draft a charge. Remember, charge is the process as well as the instrument. So the instrument which will be registered is also known as a charge. So this charge is to be prepared by the advocate of the bank. After you have prepared the charge, remember it's a draft. Why am I calling it a draft? Because it has to be approved by the other party. You remember, it's not a unilateral agreement. It's an agreement between the two of you. So once you've drafted the charge, you'll send it for approval if necessary. But in most cases, it's in the basis of take it or leave it. The bank always is a dictator in that, but there may be genuine mistakes which can be rectified. So the borrower has a right to seek independent legal advice from his own advocate. So in this case, you are sending this draft charge to the advocate of the borrower. Of course, the advocate of the borrower will have to consult with the client before they can make any approvals. Then what next? After you have given the draft, the advocate of the borrower will either recommend any amendments, if any. And if those amendments are recommended, you as the advocate will consult with the bank before you can effect those amendments. Remember, you are but acting for the party. The main parties here are the bank and the charger. So your role is simply to take instructions and just to give that legal technique, know-how. So what you'll do, you will consult with the bank on those amendments, then you effect those amendments, then you return it for approval now. If they approve it, they will send it back to you, informing that now they have approved it. And now you give them the final copy now for execution. So this final copy, that aspect of just confirming that this is the final copy for execution is known as engrossing. Engrossing simply is marking it as the final document for execution. So there will be engrossment of a charge so that you can send it for execution. Remember, we had said that for any contract in disposition of land, number one, it has to be in writing. Number two, it has to be executed by both parties. And number three, it has to be attested to by a witness who was present when the parties executed. So in this case, already you have prepared, it's already in writing because the charge is in writing. The next thing after it has been engrossed, it's now to be executed. So you will forward the document after engrossment, you engross it and forward it to the borrower or his advocate for execution. So the advocate is not executing, he's facilitating the execution by the borrower. His work is to attest that, yes, I confirm that so-and-so appeared before me and he understood the contents of the charge before he signed. And specifically, there is something that I really want to insist, and maybe in our subsequent classes, we shall be, when we'll be delving about on this aspect, when we discuss charges, there is section 90. Section 90 provides for the remedies of a chargee in case of breach, which remedies includes selling the property of the charger, which is known as, common in legal terms, known as statutory power of sale. So during execution, the charger needs to confirm that he understands the effects of section 90. He understands the effects of section 90, which basically provides for the remedies of a chargee in case of breach. So that is another important aspect during execution. So after you execute, you also ensure, as an advocate of the purchase of the bank, ensure that the execution is done in accordance with the law. Remember, you have to confirm the witnessing advocate, and that was in the case of Ndolo Aya case. So you have to ensure that it has been executed by a qualified advocate. Then, of course, it is at that point that now you need money. You will also, at that point of execution, you will need money from the borrower. And this money from the borrower will be for the payment of stamp duty. Payment of stamp duty. So money is obtained from the borrower, but the person who pays this money is the one who lodges the charge for registration. And the one who lodges the charge for registration is the advocate of the bank. So the money is obtained from the borrower or the charger, but the actual lodging of the charge is done by the chargee's advocate. So we are done at that point. So ensures that parties have obtained all the relevant consents. There's so many consents we'll be discussing, but one consent that you should not forget is the Land Control Board consent, which is actually governed by the Land Control Act. So after that, you've obtained money for registration and you are well. You now confirm that execution has been done in the best way by the borrower or the charger. Then you now facilitate the execution of this contract by the other party. The other party is the bank through the officials. They will execute, and if it is a bank, if it's a company, it has to be attested to by an advocate, personally by an advocate. So you will go and confirm that it has been, they have executed, then you attest. Attest is just confirmation that they understood the contents and it is that you witness. Thereafter, you proceed for registration. But before registration, in every conveyancing process, you have to pay stamp duty. So you will have to pay stamp duty first. And stamp duty, I said, it varies depending on which instrument you're dealing with. When you're dealing with charges, the stamp duty is pegged on the loan which is borrowed. And what is the percentage again? Who can remind us of the percentage?
If it is within the municipal whatever, it's yes, 4%. If outside, it's 2%.
That is for a transfer, but we are dealing with a charge.
I don't know.
Who wants to try? Oh, you say that I'm moving fast. Sorry. You know, I'm trying to beat time because we started late and I have to wake up tomorrow to go to work. So I'll extend a little bit for 30 minutes, or maybe 1 hour to 11. But yeah, I'll be going to work tomorrow. So that's why I'm really trying to rush.
Okay, we will appreciate, sir, but also, now that you will extend, just move a little slow so that we will also understand instead of just rushing and I'm trying to process the first sentence, then before I process, you've moved.
Okay. That is noted. But from until where we are, you understand, is the procedure flowing?
Yes, it is.
It is flowing, right?
Yes.
It is flowing.
Correct. So stamp duty, I said stamp duty is not standard. It will depend on the instrument you are dealing with. And if it is a transfer, which we are finished with, it is 4% of the purchase price if it is in a municipality, or 2% if it's outside a municipality. But now we are dealing with charges. What is the percentage? There is a whole topic. Of stamp duty, which I think we shall also be discussing as we proceed with our subsequent classes. But as one of you has correctly pointed out, it is 0.1 of the amount borrowed, of the loan borrowed. So you see the difference. That one was 4% or 2%, depending on where the land is located, of the purchase price. But now this one is 0.1% of the loan borrowed. So then you will proceed to pay the stamp duty. After you pay the stamp duty, you now proceed to lodge the charge for registration. You lodge the charge for registration. And who does this? It's done by the bank's advocate. So you will proceed to lodge the charge for registration. After you lodge it for registration and it has been registered very well, now you conduct a post-registration search. Why do you need to conduct a post-registration search? You need to conduct a post-registration search to ascertain that indeed this charge has been registered. Especially in the bank, you want to be quite sure that it has been registered. So after you are done with that, you now forward the documents. They are known as perfected documents, simply the registered documents. You forward them now to the bank. As an advocate, remember, we are still dealing with the duties and the process of a charge with regards to the bank's advocate, or the chargee's advocate, or the lender's advocate, whichever word you want to use. The legal term is the chargee's advocate. So you will forward the perfected documents to the bank with a report on the title confirming registration. You're just telling them, yes, that pursuant to your instructions to register this agreement, we have done this and we have registered the charge. It is, so you are forwarding the perfected documents to the bank. It is after this that now the bank will release the loan. It is at this point that the bank will release the loan and for onward transmission to the charger or his advocate. So you see the process. The loan will be given after the registration. Then after that, what is expected of you as an advocate, you complete your accounting and you can follow up on your fee payment. So this is just on paper. Fee payment, we will want that fee payment even before we start the process. So that is it. That is with regards to the bank's advocate. Now let us come to the borrower's advocate or the charger's advocate. At that point, when the bank has issued the charger with the offer letter or happy letter, whichever way you want to call it, the charger will go and appoint an advocate of his or her choice to act for him in this manner. But remember, in some instances, one advocate can act for both parties, but again, that is very cautious. cautiously, because we shall also be discussing what is the danger of acting for both parties with regards to conflict of interest, And again, we shall say, I shall discuss with you, let me even discuss it right now, that if an advocate is acting for both parties, he has to disclose to both of them that he is acting for them. Number two, if there is any information that an advocate knows that he feels that, or that he has an understanding and believes that the other party does not know, you as an advocate, you have an obligation to disclose such information. Number three, if you choose to act for both the charger and the chargee, or if you choose to act for both parties in any conveyancing transaction, those parties, they simply waive their rights of over-representation. You cannot represent them. Why? You cannot go to court as a witness against your client. Remember, you acted for both of them. So you cannot go there against your client. So they waive their rights over representation. So let's now come, assuming now the vendor, I mean, not the vendor, I keep calling the vendor, it's not the vendor, it's the charger. The charger or the borrower. The borrower has settled on an advocate. Let's assume this advocate is known as Julie Atienogolla or Kennedy. So what happens? They will discuss the offer letter. This offer letter, you will want to make this charger understand the implications of the offer letter. What is he getting himself into? So you will break it down for him to understand. Then after he has understood and he tells you, gives you a nod that this is a good thing, you now obtain all the consents, every clearance, including the title documents. You obtain all those things, but so that you can transmit them to the bank, or you can forward them to the bank. That is if they were not taken during the application. And it is at this point that I want to introduce something which is very important, and I want you to note it down. Undertaking in instances of a charge. Undertaking in instances of a charge. There are two main points that I want you to capture when we're dealing with undertaking in charges. You see, the charger, through the advocate, are transmitting or are forwarding their documents to the bank. What is the guarantee? What is their guarantee that the bank will use these documents without destroying them, without using them for any other? Because when you take a loan, and this loan, you are using your property as security, all the title documents will be kept by the bank, safe custody in the bank. So yes, you'll use the property, but the title documents will be with the bank. So what guarantee do you have? So at this point, as an advocate of the charger, you will be expected to request an undertaking from the bank's advocate or the charge's advocate. And the undertaking will be in two instances. Number one, that they will not use the documents in their custody or in their possession for any other use other than for the registration of the charge. But I say they will not use those documents for any other purpose other than for the registration of the charge. Number two, undertaking. So mostly these undertakings, you will put them into one undertaking, but you have to capture those 2 points. Point two, or thing two, that upon registration of the charge, they shall release the loan amount to the charger. Upon registration of the charge, they shall release the loan amount to the charger. So those are two undertakings. So you'll obtain the title documents usually upon a professional undertaking, obtain professional undertaking from the lender's advocate that they will not use the title document for any other purpose other than for the transaction. then they will, after now they have obtained, you remember we said that the charge will be prepared by the chargee's advocate or the bank's advocate, and it will be forwarded to the bank, to the chargee's advocate for approval. So what is your work here? As the advocate of the charger, you will be required to explain the contents of this charge, breaking it into digestible, breaking it in a way that the charger will understand. So explain the contents of the charge to your client and its effects, including Section 90. Section 90 of the Land Act, which basically provides for the remedies of a chargee in case of a breach of any agreement. So after you've discussed with him or with her, you proceed. The other duty is now to approve this charge. But now, having discussed, we are quite satisfied with it. Now you approve this charge and you will take it back for engrossment. Remember, after it has been engrossment, then you will proceed now to execute. You facilitate the execution of the charge by your client, who is the charger. At this point of facilitating execution by your client, that point, the client will now, you will now ensure that you obtain that money which we said, that is obtained from the charger, the stamp duty. So you will obtain it for onward transmission to the chargee's advocate. So you'll obtain the adequate money for stamp duty for onward transmission to the chargee's advocate. Then that is it. After that, after so long as you've executed, your work ends there. The other thing is now on the bank's advocate to proceed with the registration, just as we explained. And that is the process of a charge. Is it difficult? Now let me go back to what happens if the advocate who issued the power of professional undertaking ceases to be chargee's advocate and the chargee breaches their obligations under the charge? Oh, what happens in such? Of course, when you are, you see, a charge is not a complex thing which will take years. A charge can actually take weeks or even months. But if you are to leave that, then that firm, when we'll be discussing about professional undertaking, we say that if a partner has given a professional undertaking, then it binds all the other partners in the firm. So yes, they will be responsible for fulfilling. Of course, if you give a professional undertaking, you ensure that you fulfill it because you will be personally liable. So even if you leave, you ensure that before you leave, you have obtained all which you are expected to have to give to the client, because you will be personally liable for that undertaking. Let's now go to the first things now, having discussed the procedure. I wanted you to just understand the flow. Now, a charge, as I have mentioned, basically, it is using your property as a security without necessarily transferring that property to the bank. Without necessarily transferring that property to the bank. So, it confers security for loan with undertaking of repayment. In Section 80 of the Land Act, it's very clear that charges only operate as security, not as a transfer. Why am I insisting on this? Because this one will be used to distinguish between a charge and a mortgage. So this simply means that property is neither conveyed nor transferred to the lender. In case of a charge, the interest will only be conveyed to the lender in very legal and abstract way. And that is through a statutory power of sale. If you fail to meet your obligations under the charge. So allow me to go to mortgages. What is a mortgage? Mortgages simply is the transfer of interest for purposes of securing interest or for purposes of securing payment of money. So in a mortgage, you are transferring land to the bank. So the nature is the transfer of interest in land or other property. So what is the distinction between a charge and a mortgage? A mortgage conveys or assigns land with the provisions of reconveying that land after you service your loan to completion, while a charge only confers rights to the chargee to enable him recover money plus interest. There is no transfer, but only a security exists. So in a charge, there is no transfer. It's only a security. Basically, what I have said, that a charge is just but an encumbrance on the title. In section 65.4 of the land registrations, the registration, charge shall not operate as a transfer, but shall have the effect as security only. Now, types of charges. We have very many types of charges, but these types of charges, we can summarize them into two main categories. So let me start with formal charge and an informal charge. What is a formal charge? As the name suggests, it is in a formal, it's a formal arrangement. So in a formal charge, it's in a prescribed instrument, the charge that we were talking about. So every aspect with respect to the requirements of the Land Act, with regards to the agreement, they are reduced into writing, into a formal document. And this document, which has to be executed by both parties, and this document is registered. So that process that we've been discussing is actually the process of a formal charge. So a formal charge only takes effect upon registration. So that if you don't register a formal charge, then it's like you've done nothing. You have to register it. So a formal charge shall take effect only when it is registered in the prescribed register. And that a bank or a chargee cannot exercise any of its remedies under section 90. Remember, those remedies run from section 90 going to section 100 and something. So you cannot exercise any of your remedies unless it is so registered. So that is about a formal charge. How about an informal charge under section 79.6 of the Land Act? This is not in a prescribed document. It's simply an undertaking. You give an undertaking to the bank. So you write, and just like a normal undertaking. You see, an undertaking is always one-sided. It is not like parties will execute registration. No. What you do is that you make a written undertaking of your interest, of your interest to create an informal charge. So it's basically a written undertaking to charge land or interest in land, and you will be required to deposit with the bank the title documents. You will be required. So you give an undertaking to the bank and you deposit with the bank the documents, the registration documents. If it is a lease, certificate of lease. If it's a title, certificate of title. Remember, nowadays we don't have title deeds. We are even facing them off. That's why there is migration. Nowadays, in the new regime, we have the land. I mean, we have the certificate of lease, if it's a leasehold, or a certificate of title, if it is a freehold. So basically, an informal charge is a written undertaking, a written and witnessed undertaking from the charger, which is accepted by the bank or the chargee in this case with an intention to charge. So, but it's very important to note that banks occasionally lend minus any legal deeds being perfected and registered. So it's very rare to find informal charges. It's very rare, very, very rare. Banks will always have the deeds, the documents perfected. Perfect simply means registration, etc. So deposit of certificate of title or lease documents or any evidence of ownership or any undertaking observed by custom. So that is basically the informal charge. Having understood that, we also want to distinguish between equitable charge and a legal charge. Legal charge is the same as a formal charge. Equitable charge is the same as an informal charge. So you can stroke formal stroke legal charge, and you can stroke informal stroke equitable charge. That is it. Now, we are in further charge versus second or subsequent charge. I want to explain this in a very simple way. Assuming at the point when you are applying for the bank to give you, applying to the bank to give you loan, you wanted a loan of 10 million, but the value of your property is 100 million. So on this instance, you needed money maybe for development. Maybe you wanted to just build a school, or maybe so you wanted to just build your home. So you go to Equity Bank and you borrow 10 million. Remember, the value of your land is 100 million, but you only choose to borrow 10 million from Equity Bank. Then before you complete this loan, something comes up. You have identified a very good project in Homa Bay. So what happens? You go back to Equity Bank because maybe you want to engage in fishing in one of the beaches around that lake. So you want to form fish cages. You go back to Equity. You tell Equity that I need you to give me more money. But remember, the value of that property was 100 million. The first time you borrowed loan, you only borrowed 10 million. Now you are coming back to Equity to take 20 million. Now in that instance, Equity will be giving you another 20 million, though you have not completed paying the 10 million. That is known as a further charge. So what is a further charge? A further charge is basically obtaining additional money or facility from the same bank or the same lender using the same property, and you are the same borrower or the same charger. So additional money, same lender, same borrower, same property. Additional money, same lender, same borrower, same property. The only thing, the other one, you borrowed money to build 10 million. You want to construct some fish cages along Wadianga Beach in Homa Bay County. You borrow another 20 million. So that one, you are getting additional money from the same bank. That is known as a further charge. What if, after taking your 10 million, you realize that Equity's interest rates are very high? So instead of going to Equity, you decide that, no, let me try for this 20 million, let me try KCB. So instead of going to Equity, you go to KCB to get the additional money. Remember, you have not finished servicing the 10 million, but you are going back to another bank to obtain additional money. That is known as a second charge. And second charge is also known as subsequent charge. So second charge is synonymous to subsequent charge. So what is a second charge? Second charge is simply going to a separate lender using the same property, and you are the same borrower, to get additional money. So a separate charge over the same property to a different lender. So there is a new party in form of a second lender or a financial institution. So I want to explain something with regards to subsequent or second charge. for you to obtain a second charge, meaning that you are obtaining additional money from a new lender altogether. Remember, you had already obtained money from equity and you have not serviced this loan, meaning that the title documents are still with equity. So what will be required of you is, number one, equity has to consent. They have to give their consent before KCB Bank can give you a loan using that same property. So what are the disadvantages of this KCB Bank, this second chargee or subsequent chargee? Number one, you do not hold the title. The title will be held by the first bank. Number two, if at all there is breach, and there is breach of the charge, the covenants in the charge, including not paying the loan amount, the first chargee can decide to dispose of the property by way of statutory power of sale without involving you, to your exclusion. He can even sell to your exclusion. Then number two, we are going to talk about something in, I think, in the next 2 or 3 slides with regards to priority. The first chargee will always rank prior to the subsequent chargee, meaning that even when it comes to settlement of the debt, you have to first settle the first chargee before you can settle the subsequent chargee or the second chargee. So how do you remedy this? How do you remedy this? Sometimes you will want to remedy this because you can decide to have a clause in the charge, especially that, of course, you have to agree with the first chargee, so that these charges, they will rank in something known as pari passu. Pari passu. In order to remedy this, you agree that in case of disposition or sale, you will exercise those remedies together. So you rank them in pari passu. Are we together? Are we together? Now let's move. I hope you're flowing, eh?
Yes, but how do we write pari passu? I can't see it on the slides.
Pari passu is, I think, Latin pari, just the as it is PARRI, then passu, PASSU.
Thank you.
Yes. Now, third-party charges. Now you've heard of third-party charges. Assuming, let me just use Keverenge and Tonje. So Tonje wants to borrow loan from a bank, but Tonje does not have a property. Tonje does not have land. But Tonje has a good friend, Keverenge, who has land. So what happens? Tonje talks with Keverenge to allow him use his land as security. So meaning that in this kind of arrangement, there will be 3 parties. Number one, there will be this borrower who does not have security, who does not have property, and he will just remain as a borrower. Then we will have this person who is not borrowing money, but he has property. This person now will be known as a charger. And then we'll have the bank. So we call it third-party charges because it has 3 parties: the bank, the borrower who does not have property, so he will also be included as the borrower. Then we have the charger, who is not borrowing, but is just using his property. So in other words, the charger acts as a guarantor to ensure that the borrower pays the monthly installment and services the loan. It's akin to what happens in courts, especially in criminal, where you are released on bail. You see, you are not a criminal. Your property is used so that your work is to secure the attendance to court by the criminal, the accused person. Let's not call them criminal, because that is being going against the presumption of innocence until proven guilty. So the accused person in that scenario will, the guarantor in such scenario will be just to guarantee or to ensure that this person attends the court's hearing. The same thing when we come to third-party charges. The charger will act as a guarantor to ensure that the borrower pays the monthly installments. So what are third-party charges? In this instance, the borrower does not have enough security, and so they request somebody else to borrow on their behalf. So the charge will create a charge between the charger, that is the person borrowing, and the borrower, person requesting to be advanced but has no security. Such kind of charges have three parties, and that's why it's known as third-party charge. Is that okay? Is that okay?
Yes.
Yes, it is.
Yes, that's okay.
I want you to draw some chart on your books. Remember, I said that we are dealing with a property worth 100 million. From the beginning, we say that we had already valued. I'm just using this as an example. The value of the property that we are using here is 100 million. So the first one, let's say that equity gave you 10 million for construction of your house. Equity gave you 10 million. Then you realize that you got some good business in Homa Bay that I have just said, to construct some fish cages in one of the beaches around. So you borrow 20 million, let's say from KCB, 20 million from KCB. Still, you can still borrow with this land because the value is 100 million. You've only borrowed 10 million plus 20 million, which is 30 million, meaning that you can still borrow up to a tune of 100 million, meaning that 70 million still you've not borrowed. You can still borrow because the value of the land allows that. So assuming that you again decide, no, this Equity Bank, this KCB Bank, I think Erin Rudi Equity. So you go back again to Equity, and Equity gives you another 10 million, maybe to just have your holidays in Dubai. So 10 million. Up your writing there. So write A, the first Equity, just write Equity, 10 million, then KCB, 20 million, then Equity, 10 million again. Then you decide, no, these banks, some guy gives you a good advice that you can try National Bank. So you go to National Bank, borrow another 10 million. Then you say, no, let me explore again. You go to Chase Bank, you borrow another 10 million. So what is the first one you borrowed? 10 million from Equity, 20 from KCB, 10 from Equity, then 10 from National Bank, then 10 from Chase Bank. Now, priority. I said that because I want to talk about priority. The rule of priorities, it organizes interests in ranking, so that ranking is conferred upon by means of registration. So we shall look at the registration. When was this registered? So in that case, the first one to be registered was Equity, then KCB, then Equity, then National Bank, then Chase Bank, in that priority. So the general rule is that the charge which is first made is first paid. So the first one to be made is the first one to be paid. So, and the priority I've said is conferred by registration. Section 81 of the Land Act, the first registered charge has priority over all others. And this process is the same with subsequent charges. You noticed that when I gave the procedures, I said Equity, then I came to KCB, then I came to Equity. So from the definition I gave earlier about the distinction between further charge and subsequent charge, the equity will be the original charge, but when KCB becomes second or subsequent charge, but then equity comes again. So equity with regards to equity, the first equity bank, the first equity loan, this one will be further charge. But I don't want to talk about that. I'll talk about it in the next slide. So what happens is that priority will be conferred by registration. So that equity, the 10 million for equity will be discharged first, then the 20 million for KCB, then the 10 million for equity, then the 10 million for National Bank, then the 10 million for Chase Bank, in that order. That is about priority under Section 81. One thing I want you to understand and underline is that priority is conferred by registration. Priority is conferred by registration. Now, to another important thing, tacking and consolidation. Tacking and consolidation. Let's start with the tacking. I gave you that list. We said that we are still going back to what you just written down. We started with Equity Bank. Then we went to KCB. Then Equity gave another 10 million. Then 10 million from National Bank. Then Chase Bank gave 10 million. So what happens about tacking? Ideally, on the rule of priorities, the priority should be that you should pay off equity first, then you pay KCB, then you pay equity. I just want to stop it at that point first before you get good. So meaning that when you were discussing, that's why I'm insisting on the difference between further charge and a subsequent charge. You see, the first bank to give you a loan was Equity Bank. And so when KCB came, KCB becomes subsequent because, or second charge, because it's a different money lending institution, though the same property. But when equity, again, you go back to equity, that with regards to equity, it will be a further charge. But the priority of charges dictates that you should discharge them or you should pay them in their priority. But tacking is an exception to this rule. How? Equity can decide to take the further charge that it advanced. Remember, it advanced the first 10 million, then after KCB, it also advanced another 10 million. So ideally, the procedure should be equity, KCB, then equity. But equity can decide to take this second loan that it gave to this person so that it tax it in to the first loan so that it ranks prior to the KCB bank or to the second or subsequent charge. That is known as tacking. So what is tacking? Tacking is the right of a secured lender to add further monies to the security so that those further monies are also secured and they rank prior subsequent charges. So the further advances shall not rank in priority. There's something that I also want you to understand. They will only rank in priority if it was clearly or expressly provided for in the charge, the initial charge, that further monies that will be advanced by you shall also rank in priority of other subsequent. So number one, it has to be provided expressly in the charge. Number two, for the further charges to be tacked, the lender must, the subsequent lender must also consent. Look at section 82. So he has to consent to this in writing. So meaning that a subsequent chargee has to consent in writing to the priority of further advances. So where a charge provides for payment of principal amount by way. So basically that is it. I want you to understand it from that aspect, that tacking simply is making further advances to rank in priority or prior to subsequent charges, which came before them. How about consolidation? How about consolidation? Allow me to give you this example. So I'm done with the first example, those equity banks, etc. I'm done with them. So let's now come back. We still having our land.
Mr. Osaga, I'm so sorry to interrupt.
Yes.
but I'm a bit confused here on tacking. Could I just take you back a bit? Still using the same example we've been using of the property worth 100 million. Could you explain it again just one more time? I'm so sorry, just one more time.
That's okay. That's okay. Maybe before I can answer you, there's someone who is asking, should all subsequent charges also be registered? Yes, because priority is conferred upon registration. We said that for a formal, remember these are formal charges, both of them. The only thing that they come later. We said that you cannot exercise any remedy unless they are registered. So you have to register them, Lucy. Now let me come back to who asked the question?
Annette.
Okay, Annette. So Annette, what happens in tacking is that you take the further advances. Remember, I said that the first bank was Equity, which advanced 10 million. Then KCB came to advance 20 million. Then Equity came back to advance another 10 million. So in the normal process with the priority of charges, the normal process or the normal priority should be that you should discharge the charges basing on when they were registered. So in this case, Equity will be discharged first or be paid first, then KCB, then Equity. And remember, I said I defined the difference between a subsequent charge and a further charge. So this second charge by Equity or this second advancement by Equity is a further charge on there or with regards to Equity Bank. But when KCB came, KCB with regards to Equity, KCB was a subsequent charge. So what is tacking? Tacking is basically a bank which had given initial money, making those further advances which it has given after a bank had come in between, a subsequent charge had come in between, so that these further monies shall also rank prior or before the subsequent charges. So that they can also rank prior. So you will pay them, though you gave them late even after you had already given the subsequent charge, but simply because they have advantage that they have their big brother, they have, let me say the big brother, they had someone, the initial charge was the bank, the same bank, they can still get into that arrangement so that all their further advances can also rank in priority to all other subsequent charges, and that is known as tacking. Is it okay, Annette?
Yes, it's very clear. Thank you.
Correct. So let's deal with consolidation. So we are going to Equity again. We are going to Equity Bank.
Wasaga.
Yes.
I have a question.
Kindly.
So when you are making these subsequent or further charges,
yes,
is there a reevaluation of the land? Because you see land appreciates with time, so that if it was initially 100 million, you can continue making further subsequent charges up to maybe 110 million because there's a periodical reevaluation of the land. Does that happen?
Yes, you can reevaluate the land. That's okay, but normally it may be because of the processes, and then you see you are not selling it. But yes, you can reevaluate that land. But it's rarely practiced. Mostly people will go with that initial value which was given by the first chargee, depending on the period upon which you are paying that. There is no harm in reevaluating that so that the property will be increasing in value as time goes by. Is that okay?
Okay, thank you.
You're welcome. So let's go to consolidation. And we are still using Equity Bank. So assuming, in this case now you have land A. So this one, we are not going to use our land. So we are going to use, so you have land A. Land A is worth 100 million. Then land B is worth 10 million. So you have different lands. Land B is worth 10 million. Land C is also worth 10 million. Have you written that? So land A is worth 100 million, land B is worth 10 million, land C is worth 10 million. So you use the first land to borrow loan from equity, and that loan that you borrowed from equity, let me say that you only borrowed 20 million from equity, though the value of the land is 100 million. Then you decided, no, I don't want to exhaust this land. Let me use another land again. You go back to equity again with this land worth 10 million to borrow the 10 million or any amount you want. You borrow that 10 million using that land. Then you say, no, and you also want to use the third land. You also go to equity and borrow another loan. So meaning that you have used all these properties to borrow money from the same bank. You used all this property to borrow money from the same bank. So what happens? What happens in such instances? When all these loans fall due the same time, what happens? You can decide to do something known as consolidation, meaning that you discharge these properties with low value without without paying them, so that you can combine them, or I think that's the best term I could use, combine them to the property with the highest value. So that, remember, that property was worth 100 million, you only borrowed 20 million. So if you decide to bring this one, so you don't pay for them, you discharge them, but you consolidate them to this, so that if you bring this 10 million, let's say you borrow 10 million, the other one you borrow 10 million, you now consolidate them. Remember, the value of this land is worth 100 million. So even if you bring this 20 million, 10 million, it will only be 40 million. So meaning that you have brought those loans and combined them into this property with the highest value, and you've discharged those other properties without having paid for them. That is now known as consolidation. So in consolidation, you have to have the same bank and different properties. So what is consolidation? This must be provided, and again, this one also must be provided for expressly in the charge instrument. That right of consolidation, it must be provided for. So this is where a charger who has more than one charge with a single chargee on several securities may discharge any of the charges without having to redeem all charges. So a chargee who has made provisions of consolidation of a charge shall record that right in the register or registers against all charges so consolidated that are registered. So that is basically what is meant by consolidation. That is basically what is meant by consolidation.
Okay, so if I may ask, what are you saying is the advantage of consolidation? And also somehow you brought also another new term, which is redeeming, and
Yes.
I ended up not understanding some bit.
Redeeming is simply servicing. Redeeming simply paying. Yeah, redeeming. You're paying that loan. You're paying off that loan. Eh? Servicing that loan. So redeeming is the same as servicing that loan. Paying that loan. Is that okay now?
Yes, and now what is the importance? What is the rationale for consolidating again?
Or the rationale for consolidation. You see, you are discharging all those properties, so that they can. So instead of, if maybe one of them fell due, instead of and you are not ready to maybe discharge it, you're not ready to pay for it, instead of maybe allowing the bank to sell that property which is of a smaller value, you can decide to consolidate it if this one is of a longer period, so that you can be dealing now with the payment and redeeming of that property. So it's just simply discharging all these properties so that you can do, because when you're dealing with a charge, your rights are confined, your rights are limited. You cannot just use that land as you wish. You cannot just use, in fact, you cannot sell it without the consent of the bank. So if you want to sell them, for example, you can decide to discharge them without having to pay them, so that you consolidate them and you sell them. You get the rationale now?
Yes, I do. And what do you mean when you say instead of paying for it? What does it mean? I mean, paying where for this particular piece of land?
You see what happens is that you borrowed money from the bank using these properties. Remember, I said when I gave land A, land B, and land C. So land A was worth 100 million and you only borrowed 20 million. Land B was worth 10 million and you borrowed 10 million. You can this is just but an example. Land C is also 10 million and you borrowed 10 million. So, you have to service all these loans. You have to pay all these loans for you to discharge that land. Discharging land, it simply means that after you pay that loan, now the bank, the encumbrance is now removed. That is the process of discharging, so that that land is free from any encumbrance. You can deal with it the way you want. So you can decide that instead of paying all these monies or having my land just charged, and there is one land that can accommodate them, let me discharge it. Discharging simply means you are paying, you instead of paying for it, you are discharging it so that that burden which it had, it's also added to the one with the highest value. So that is why you are without paying for it, and without redeeming the loan as required. Because ideally, if you borrow money using the loan, if you borrow money using your property, you have to service that loan. You have to pay for that loan until you have completed every installment, every interest as provided for. But in this case, you're saying, no, I am not going to pay for this because I have another land with a higher value. So what should I do? Let me just ensure that I add that burden so that whatever was supposed to be paid by this land, because all those lands belong to you and they are also from the same bank. That's why I say the same bank. So you are discharging this one and you are adding. So instead of paying for the 20 million, you will have to pay extra on that parcel of land with the highest value because you've added something on top of it. Is that okay?
That is very okay. So is it proper to say that you have consolidated the loan, or is it proper when you say that you have consolidated the land?
Consolidated the loan.
All right. Thank you. Thank you.
Okay, yes.
Excuse me.
Consolidation of land. Okay, yeah, proceed.
If I may ask, you mean
Yes.
that land B and C will be free from charges?
Yes.
Okay.
And their burdens will be that loan now will be taken to the first land with the greatest value. So instead of servicing the 20 million, now you've added another 10 million. So you'll be servicing 40 million on that land before it can be discharged. And these ones will be free. Is that okay?
Yes.
That's okay, sir. You may check from the chat. Someone is trying to ask a question.
Okay. Oh, for more inquiries about the classes, reach Atieno on that number kindly. If you want more of these classes, because I beg to stop. Because we can pick it up. He holds the certificate of title when you. Hey, who holds the certificate of title when you have loaned? Certificate of title, I said that it's the bank. The bank will hold that certificate until you have redeemed your loan, until you've paid your loan in full. That's when there will be something known as a discharge. A discharge will be lodged, and after a discharge has been lodged, it's been registered, it's also part of the notes. That's when now that property, that title will be given back to you. So it's held by the bank. And we said that when it comes to subsequent and further charges, the first bank will be holding those documents. And those are some of the disadvantages of a subsequent charge, that they don't hold the title documents because they are held by the bank, the first bank.
So the first priority, the bank with the first priority after they have gotten their loan, does now the title move to the second in priority bank?
Yeah. Or if they have gotten their loan, yes, it moves that way.
All right.
There is a very good question here. What would happen to the advance facility if the charger died on the course of remittance? Now, what happens is that when it comes to death, and that is also part of the lessons we will be discussing. You see, I just gave you a summary of what happens in the land sale transaction. In a land sale transaction, there is a transfer. Now, transfer is a topic which we can discuss and discuss. So on the transfer, we have transfer by operation of the law, which is basically sale or a gift. I mean, by act of parties, which is by sale or a gift. And there is transfer by operation of the law, which is also known as transmission. So when you die, your property, depending on how it was, if you are the sole proprietor of that land, or the sole owner of that land, or if it was tenants in common, depending, you also need to understand the difference between tenancy in common and joint tenancy, which I will discuss also. So what happens with regards to when you die, that property will go through succession. And if it goes through succession, your dependents will get that land. And when they get that land, still that land will be subject to the encumbrance. So you will have to deal with that encumbrance as dependents. So you can decide to discharge it. You can decide to pay for that loan before you can proceed to transfer it. So basically, if you die, that property will have to go through succession.
There's a question from YouTube. I've posted it on the chat.
Yes. Question from YouTube, Dr. Hassan Kinywa Omari. Please advise. I hear people saying that one can deposit their title in the bank for safekeeping. What is the advantage of this, and how is this charged? Oh, depositing your title without actually charging it, eh? That one, it's not within the ambits of conveyancing, because, you know, if you're just putting it for safekeeping, it's like you putting it in a safe box. Yeah, you agree with the bank, and yes, the bank will keep it for you. But that's different from charging, if I understood your question correctly. Because in this case, it's like you are for safekeeping. Yes, you can keep it anywhere. You can keep it in a safe box, you can keep it in the bank, so long as you agree with the bank that this is what you'll be paying as a result of that. That's just a contract, like you can give me a title to keep for you. But if you are using it to obtain loan, then it becomes a charge. What would happen to a charge if the chargee becomes bankrupt or insolvent? Now, those are the remedies of a chargee. The chargee can exercise their remedies under Section 90. Number one, they can sell that property. If you're not able to pay your loan, they can exercise their statutory power of sale. They can sell that property and get their money. So they are part of the creditors. So when you are going through the process of bankruptcy procedure, they're part of the creditors. So they can decide to sell that property and exercise their statutory power of sale. They can also decide to lease that property and get the amount. They can also appoint a receiver. All those are remedies under Section 90. So when you die, when you become insolvent, that is not the end of it. The bank can still proceed to exercise their rights. Is that okay, Langat? GK Langat, is that okay? Is that well with you? Thank you. So allow me to, unless there is any other question.
When can we get this recording?
Okay, you will liaise with Julie. You liaise with Julie. And we still have a long way to go, because we just discussed the basic, because we could not go very fast. If we went very fast, we would have not really captured so much. But then we have on charges, we have about 57 slides. I think I have discussed the basic ones. We will also have the other things here are the basic requirements of a charge. Then we also have forms and contents of a formal charge.
Wasaga, are you still there? Wasaga? I can't hear you.
Hello.
Okay, let me try and get to Wasaga. It's Atieno. Let me try and get to Wasaga.
Sorry, I had a technical hitch, but I'm back. So I just want to also thank you so much for joining this class. I hope it was of benefit. If you want to join more of our classes, kindly reach out to Julie. The number is on the screen, 0714-88492, or send an email to her so that, yes, you can also get my number from Julie.
Yeah, thank you, Wasaga. I sincerely appreciate your time. Indeed, you have really done so much for us. We really appreciate you, Wasaga.
Julie,
yes?
if I may.
Yes.
So good evening, everyone. My name is Muthami. I'm the class representative for Class B. I also represent the students as a whole at the SGC, at the mentorship committee. And I would say that on their behalf, we really appreciate. We do appreciate you people, what you have covered. I do not know how many weeks we could have taken to cover that. We do really appreciate. Yes, thank you so much.
Thank you so much.
You.
Thank you.
Yeah, so I'm typing my number. I've typed it again. The email atienogolla@gmail.com. So yeah, reach out to us. We have various packages. We have the syllabus classes, we have oral preparation, we're helping people with their project work. We're also having speed drafting classes, one-on-one classes. So we are really being here for you. And yeah, reach out to us so that we can know how we can be of help to you. Thank you for logging in. It's almost 11 p.m. I appreciate your presence.
Julie, they are also requesting for the slides of this class, kindly.
Okay, I'll discuss, but I think it won't be possible because you see, this was a free class. So, and I shared with the rest of you that we are going to be putting the slides on a platform. So we'll just share the recording.
Thank you so much, Julie. So Julie, so utatumalizia kwa maombi now as our principal. Julie is our head teacher here.
Okay. Yes. Let's pray. Lord Jesus, we thank you so much for today. We thank you for your grace and your power that we've been able to have this class. We thank you so much for the students who logged in. We thank you for Wasaga. Lord, bless him. Continue giving him the strength and the knowledge each day. I continue praying that all students who continue coming to our doors, may they always leave having achieved their goals, which is getting done with the KSL bar exams. Father, as we sleep, give us good night's rest and enable us to see the next day and keep us in your loving arms. In Jesus' name I pray, amen.
Amen and amen. Good night, everyone.
Amen.
Good night.
Good night.
Amen. Good night.
Amen. Thank you for logging in.
And thank you, Julie, for creating this forum.
I'm more grateful, Wasaga. Thank you for your